Thank you so much for joining the final webinar in the Medical Malpractice series by the Collaborative Attorney Alliance. I'd like to start with just a few housekeeping items. So feel free to submit questions into the chat or Q&A throughout the session, but we will hold all questions until the end. I would like to start by introducing today's moderator, Caitlin Harrington. Caitlin is a physician attorney in Seattle where she practices internal medicine and also works on communication and resolution focused projects with Sweet Law and with us at the Collaborative for Accountability Improvement. Thank you, Caitlin, for joining us today.
Thank you, Nicole, and good morning to everyone joining us. We're so happy to have you. Welcome to the fourth in a four-part webinar series focused on exploring the perspectives of those involved in medical malpractice litigation. This series is brought to you by the Collaborative for Accountability and Improvement's Attorney Alliance, and over the course of 4 months has included conversations with clinicians, attorneys, patients, and families. In today's webinar, I'm honored to welcome Dr. Jeff Goldenberg and Naomi Kirtner, Dr. Jo Shapiro, and Jeff Catalano. Together, they will share a conversation focused on breaking down the silos and exploring the ways in which communication and resolution programs can improve the process that follows after medical harm. I would like to start by introducing our discussants, each of whom has been involved in one of the prior webinars in this series. To begin with, Dr. Jeff Goldenberg and Naomi Kirtner co-founded Talia's Voice, Projects for Patient Safety, after their daughter Talia died from medical errors. Talia's Voice seeks to change the culture in medicine so that the voice of each patient is heard. Naomi completed a master's program in counseling physiology, while Jeff is a family physician with more than 25 years in practice. They are active with the Washington Patient Safety Coalition, the Oregon Task Force on Resolution of Adverse Healthcare Incidents, the Collaborative for Accountability and Improvement, and the PAC Collaborative. Thank you, Naomi and Jeff, for joining us. Dr. Jo Shapiro is an associate professor of otolaryngology and head and neck surgery at Harvard Medical School. In 2008, she founded the Brigham and Women's Hospital's Center for Professionalism and Peer Support, which serves as a model for institutions seeking methods to enhance a culture of trust and respect and to improve clinician well-being and patient care. For many years, she has been involved with the Collaborative for Accountability, serving a term as chair of the Senior Advisory Group, and now as a member of the Best Practices Committee. Jo, a very warm welcome. Finally, Jeff Catalano is a partner at Keshe's law firm in Massachusetts, where he represents victims of catastrophic injuries, including those resulting from medical malpractice. A past president of the Massachusetts Bar Association, Jeff also serves on the board of the Massachusetts Alliance for Communication and Resolution Following Medical Injury, which seeks to facilitate disclosure, apology, and compensation following medical injury, as well as on the board of directors for the Collaborative for Accountability and Improvement. Jeff, thank you for joining us. I am just so excited to have all of us together in one webinar to start this conversation. To begin with, I'm going to start with a very broad question. I would welcome each of your thoughts on the best roles of attorneys in communication and resolution programs throughout the process. And Jeff and Naomi, I'm going to start with you before we turn to other discussants.
Well, thanks for...
To Jeff, I'm sorry.
To Jeff.
Jeff Catalano or Jeff Goldberg?
Let's start with Jeff Goldenberg and then go to Jeff Catalano.
Well, thank you for having us today. And I think that the role of attorneys in a CRP process needs to begin immediately. I think that the very large hospital machine, it's an enormous machine that in some ways is stacked against the patient and family with risk managers and hospital attorneys and the entire work, the entire system, and then the little peon of a patient, in a corner by themselves. So I think it's really important to have an attorney available for the patient and family immediately. I know that for us, we had questions from the get-go. Yeah.
I think that, and really the CRP process should start immediately. And for patients and families, in that situation, not only is it good to have some representation, but you don't even know what you don't know. And I think that out of fairness and to have the process move in the smoothest manner possible, having legal representation for both sides, not just the hospital side, makes sense at that point.
And one last point before we move on to the others. I think it is also, in a way to break down the silos, right? For us, if we began calling attorneys on our own, everybody was, moving into their own corners, and you could already see the fight beginning. We had no choice. It was the only thing we could do. But I think with openness and with an attorney available for a patient and family, the tone and the narrative can be different than everybody backed into their own corners against each other.
Thank you. That's really helpful. So it sounds like really you having attorneys as a guide, and so not necessarily as a adversarial process, but more as a sort of a way to learn together. Jeff Catalano, I would welcome your thoughts on this question.
Sure, although I don't think I need to speak, because those two, Naomi and Jeff, hit the main point, which is that you really do need to invite an attorney early on in the process.
Mm-hmm.
At MacRME in Massachusetts, where I'm on the board, the only plaintiff's attorney with doctors and healthcare providers and risk managers, they are very receptive to the concept, and it's all over the materials, of encouraging, that's their word, patients to get representation early. And the reason, of course, is for some of the things that Naomi and Jeff were alluding to, which is that there's this imbalance of power right at the very beginning. What you have is an injured person or family members of an injured or dead person who at that point are full of emotions and vulnerabilities emotionally. And then you have the hospital, which has all of the knowledge, all of the experience, all the insight as to what happened. And that sort of needs to be modulated. And an attorney who does this the right way will modulate that. And to use your word, Caitlin, guide them through the process as a facilitator. It's not the opportunity, in my opinion, and in my experience doing this, to become adversarial right out of the gate. I mean, that will cause people to clam up. That will cause people to circle the wagons. It's like back in the day when that was standard operating procedure for defense attorneys and for hospitals. So with this new sea change of openness and transparency, the lawyers have to get on board with what their role is, which is managing not only the process, but their clients, because the clients probably are not lawyers, or even if they are full of all kinds of questions and concerns and anxiety and expectations. And a lawyer's role is to tease that out so that he or she can address them in a way that's productive for whatever meeting then takes place.
Thank you. That's really helpful and really, I think, ties together with what Jeff and Naomi were saying. Jo, what is your thought on this, especially from the physician perspective?
It's different, actually. And
Fantastic.
I totally, I hear what the three of you have just said. I guess, the first thing, Naomi, that you said, and you all should know that Naomi and Jeff G and I work really closely together. What you said, I just have to say, is horrible. And it was your experience, and I think it is unfortunately not unique, where you're this insignificant, the patient family are insignificant, and then there's all this machine that kind of comes at them or ignores them. What I want to say is, like, that's terrible. And certainly if that's the case, then we would need the presence of somebody else coming in from outside, like counsel. But I would hope that we would work to, on this journey where that isn't the case. There aren't sides, that this terrible thing happened. We are all in it together, and we are there, the hospital and all the healthcare system is there to serve the needs now of the patient or family. When things get to the point of, this consideration of legal concerns, then absolutely, representation is really important. But there's so many things that need to happen before that really should be about opening up the communication, about making patients and having patients and families feel heard. So I do just worry that if that we're designing a solution to a situation that shouldn't exist, and that we should work harder about making what Naomi said an absolute never. Like that should never be the case for what patients and families feel and are treated.
One thing I want to say, I think that would be great. And I think that there needs to be a transition from the concept of risk management after medical harm to risk management being the department that tries to prevent harm. Because, in our case, we had different people who were involved in Talia's care circling their wagons within days of her injury, and already starting to point fingers. And within days of her death, when I wanted some information, I couldn't get the chart because it was with risk management. So, neither worked out. And what you're saying makes sense in an ideal. I just think there's got to be some transition to that point.
Well, Jo, I wondered what you would think about the idea, though, that if it's an attorney who is CRP savvy, right? Like it's somebody known to all the parts of the machine. So instead of that big hospital machine being the hospital against the patient, it includes attorneys who are actually part and parcel the concept of CRPs. So instead of being adversarial, they're working with the CRP team and seen as an ally instead of an adversary. Because I agree with you that as soon if we're doing it in a way that it's an us against them, that defeats the whole purpose of the CRP. And one thing you said, Jeff, that maybe you're right in the ideal, but maybe there needs to be a transition while hospitals get on board with the concept of CRPs, that there can be a transition time where we haven't reached that ideal and, we're sort of betwixt in between maybe.
Mm-hmm. Yeah, very fair point. Absolutely. Yeah, I just don't want to lose the momentum to fix what you said in the beginning, like that. We can never let up on that. We have to move towards the way it should be. And I say, say ideal, but I hope that doesn't mean like, but it really can't happen. No, it really can. And I think in many instances it does. It's, unfortunately tragic when it doesn't meet that, absolute, I would say it's basic the way it should be. But yes, I hear you, because it isn't that way in many instances. How do you protect, in a sense, and facilitate having the family's voice heard when that atmosphere is not conducive to that? So I your point is really important.
Jeff Catalano, a follow-up question for you related to what we're talking about now. My sense is that attorneys are brought in fairly early in the process in Massachusetts, and I'm wondering if you have found that to increase the feeling of a sort of an adversarial process, and how you have prevented that from happening in Massachusetts.
Great question. So this addresses Naomi's concern too about making sure that the attorneys who are involved are familiar with and invested in the CRP process. And in Massachusetts, the hospitals have a list of attorneys that they provide to the patient who understand, who have invested in the CRP process, meaning they've attended a webinar that talks about how it's supposed to work. They understand the goal of it. They understand the purpose of it, even to the point where there's a discussion about flexible fee arrangement in certain cases where the case can be resolved quickly. So that gives some peace of mind that the attorney who is getting involved, that he or she is bought into the process, bought into the program. Now, that being said, when do you invite the attorney? Yes, early on in the process, earlier than people would normally feel comfortable doing, because they have this ingrained notion, and it's not unwarranted because of the way things happened in the past, of lawyers being attack dogs, and immediately they're going to start cross-examining, and this is not going to go well. Honestly, I don't think that good lawyers would approach it that way. Good plaintiffs' lawyers would not approach it that way. They'd see an opportunity for early resolution on behalf of their client, and they'd want to facilitate that as much as possible. Now, at the bedside, you can't just say, we understand something happened to you, here's a list of lawyers. At the bedside, right then and there, right after the event, it would seem appropriate, and I think this is in line with what Jo was saying, to express sympathy and concern and acknowledge that we need to investigate this, and we take this very seriously. There's no harm in saying that. And it does give people, the patient, the family, the peace of mind that they're not being brushed to the curb. That this is something that, and rather than finding out weeks later, because in that interim period of time, their anger grows, their grief grows, they get more entrenched in their position, that, they want heads on stakes. And, that makes my job really tough as a lawyer. A client who is super aggressive about wanting, to really go after doctors and all that doesn't make it easy for me to get a resolution. So I think that early on, if there's that acknowledgement, and in Massachusetts, I helped pass a bill that makes apologies non-admissible in court. I think it's very important. Doctors have that freedom now, and nurses, to apologize and not have to worry about how that's going to be used against them. And it just goes a long way to greasing the skids towards this CRP process.
I'm going to add something that I think will segue into another point that that I think all of us wanted to discuss, and I just realized that there's a little bit of a disconnect, and I see it now, which is when you say early in the process, what does that mean? So my experience, and I do have a lot of experience in being the person who, when I was working at the Brigham, was doing the disclosure communication coaching for individual clinicians or teams in having follow-up and initial conversations with patients and families, which should happen way before anybody's thinking or would even want to have a lawyer present. I mean, even for patients and families. So what I wanted to say was that, if it depends on when you say early, done well, which it can be done well. As soon as something happens, there's that communication, expression of empathy, and this goal towards meeting the patient family's needs. And also, it's our obligation and it's our commitment to really understand what happened, both so that you have the information and also so we can learn from this and prevent it from happening to other patients or families further down, anybody else. And as a result of that investigation, if you'd like to hear about what we find, we would love to include you and even be part of that. That's what should be happening. And many times the result of that, I wouldn't warrant, I would think, calling in an attorney. But I think, to be fair, I think we've got to put into this notion of CRPs, it's the whole process, whether or not we end up thinking, hey, now we should be thinking about financial restitution. That's really important. Let's get someone in here early. Let's get counsel and let them, bring counsel. And that's when we should start talking about that. That's so important to do and not wait forever. I agree with you, but you still want to have some idea of what happened. And so that I wouldn't say I would think as a clinician, if every time I went in to talk to a patient and family, they were like, I don't want to talk to you until I have my lawyer. I'm exaggerating, but maybe that's okay. But I would feel just really awful about trying to have, important conversations. So I do think when you say early, I guess it depends on when that is, because I don't want people to think of CRPs is only when we've decided, that some of the principles for CRPs should always be there, like from the get-go. Even if it turns out it was an adverse event not due to an error, still empathy, still expression of that. I'm so sorry this happened versus, we made a mistake, and which is, if we did, we have to say. So I hope you see my point that there's a whole lot that should be happening way before
or at the same time, right? Like I think it isn't a lawyer and only a lawyer who comes. Like we worked really hard on the concept of having a point person, the same person who works with the patient and family all the way through and is their person. Well, like that still needs to be a go. There is nothing, everybody who is involved in communicating with the patient and family, I think, it isn't an either or, in other words, right? And I think so.
I think I probably fall somewhere between. I agree with you that the bedside conversation that happens right away shouldn't require an attorney, but I also feel like probably it would be helpful to have an attorney at least there to advise and guide you before there's a determination of what happened and why. And that's a whole other conversation about the, what happened and why. But somewhere in between there, I think it would be helpful to have the guidance of somebody such as the folks that Jeff Catalano is talking about, who are well-versed in CRP and what the issues are.
One really interesting theme I'd like to draw out a little bit more is what Jo was talking about, and Jeff Goldenberg, I think you were saying this as well, which is that the principles of CRP should be applied across the board. So when there's a harm or something that's unanticipated, they should be applied. And I'd love to talk a little bit more about that and sort of your thoughts on how that can best happen, knowing that that is a sort of enormous task. How do you envision this in real life happening in the healthcare setting?
Well, one of the things that I would say is that the CRP process, if it is successful and moving forward throughout this country, what I would like to envision is that the principles of communication and transparency become the way communication happens in the hospital setting. So I would even go further and say not just after injury, but before injury. That's how people should be communicating with a patient. And certainly it is both the right of the patient and family to know what happened, just like if a surgeon comes out and says, we fixed the broken femur and we put stitches in this wound and we expect this long a period of time for recovery, and here's what we're going to tell you needs to happen. If there was an error that happened, it should also be part of the information that is disclosed in that setting. We went in to fix the femur, but it's your right to know that. I mean, that's just the way it should go.
Well, and I just think to add to that, so the communication and resolution programs, from my point of view, it's an excellent model of communication. And so it should be occurring no matter anytime anything unanticipated happens, it should be in place as the way communication with and about a patient and family takes place. I mean, I would go so far as to say, we've done a talk before that I call it big CRP and little CRP, where the communication and resolution program is what happens after major harm events or unanticipated events occur. But I think there are little mini hurts that happen, injuries, all the time, every day in a hospital, and the same method of communicating can and should take place, where there's an injury or a rupture and you fix it by being accountable and transparent about it and honest about it, and you figure out why it happened and you make a commitment for it not to. So to me, in the ideal world, the communication and resolution process is the way everything should be managed, as just a model of communication.
Yeah, I want to second, third that. I mean, as you know, I've been really pushing for that notion that we shouldn't be thinking of these things as, well, we only do all this if there's been major harm and we have not met the standard of care. Everything else, we can handle differently. No, exactly. And I do want to say, having been involved in this very directly, I think people really do agree with Naomi and Jeff, just what you said. Like, this is absolutely the way we should communicate with our patients and families, and recognize that when there is significant harm, it's especially hard to do. And so don't just tell us to do it. Help us do it right. That's been the focus of my work, is like, we have to support clinicians in doing this well, because if we don't, we won't do it well. And so I totally agree with you. I really do. It's got to happen. And it is happening, I think, but, unfortunately not always. And that's problematic.
One really interesting question, which has come up in what you were both saying, is this idea of standard of care. And that's a theme which has also come up in different webinars as well. And so I would love to talk a little bit about your thoughts on standard of care and how it relates to communication and resolution programs. And Jeff Catalano, maybe I'll start with you, and then we can popcorn around.
Yeah. So standard of care can be a very challenging thing to determine. And it really sometimes takes a deep dive in order to really fully understand, has there been a breach? And if so, who is responsible for that? This is not something that oftentimes, most often, can't be determined quickly. And so there has to be some period of time during which the hospital ought to be doing a root cause analysis, and during which the attorney for the patient should be given the opportunity to do a similar analysis using their own experts. The idea being that hopefully both can get to a point where they've completed their review, and this can take months to do it right. I mean, in some of the more complex cases, this can take a while to do it right. And then, at the end of the day, sometimes you agree and sometimes you don't agree that there's been a breach of the standard of care. Sometimes it's obvious. The litmus test I use is it the kind of injury where even a jury of like social workers and teachers and plumbers would say, I just can't get over how that happened. Why did this happen? If it's that kind of instantaneousness, it's an easier case. But sometimes it's not so easily determined, because standard of care includes not only was the conduct negligent, right, but did it cause the injury, right? Did it actually cause harm? And sometimes a lot of cases, there can be a delay in diagnosis, inexcusable delay of diagnosis of like 2-3 months of a lung lesion. Did that really cause any harm? And to tell a client sometimes that it didn't, because it would have been stage 3 months ago, is a hard conversation to have with someone who's not a lawyer and not a doctor. So standard of care is a very challenging thing, but I think both sides have an obligation to do a deep dive. Too often I find, frankly, on both sides, that they don't do a deep enough dive to determine if, in fact, there has been a breach, so that they can determine if, in fact, compensation is warranted.
Well, I think that one of the things I would say about standard of care and the problem with the conversation we're having right here is that if an unanticipated event or outcome occurs for the patient and the family, regardless of whether the standard of care was met or not, they're still injured. And so it's this complicated thing where it's set up as the determination of whether there's almost a case that's legitimate. But if you go in for a surgery and it's determined that the standard of care was met, but your mother still died, your mother still died. You didn't go in, she didn't go in for the surgery anticipating death as the result. And so for me, the advantage of a CRP altogether is that it doesn't matter in some ways. I mean, it's
an opportunity to be there for the family or patient who have suffered harm, period, regardless of what the standard of care was, because we
understand that the standard of care matters. It matters for fault and compensation, but the harm still occurred, and the CRP needs to address that. Because what happens, I think it's like almost, if the standard of care is determined to have been met, it's like, oh, the physicians or the providers are off the hook. And that isn't the way it is at all for the patient and family. So in some ways, it incites even more anger and sense of betrayal, because that's used as the way of saying, so see, we really did do okay. And yes, in a way, a provider who met the standard of care did, but from the patient and family's experience, there's still an injury, and they need to be taken care of on account of that.
I want to add on to that. I totally agree. I think the distinction has to be made because of just what you were saying, Naomi, and Jeff, see that it has to be used for this specific question, is around financial restitution. It has to be. That is that question is going to be asked. The model that I proposed, as far as after an event happens, an unanticipated harm, harm is that we do 3 layers of questions. The first 2 are the ones that the clinical people have to be wrestling with. The third is the ones that we need the legal people to wrestle with. The first one is, knowing what we know now, is there anything that we would do different going forward? Maybe 3 different things that we would, now that we know now, those are things, they would be improvement things, 1% improvement, right? The second question is, was any of those potential improvement points an actual error? In which case, what you have to add on to the transparency of these are the things that we look at and we wish we'd done better, and we made, this one was an error, these 2 were errors, and, apologize for that. And the third question is, was any of these errors outside of the standard of care? And that leads to, again, just a furthering of the process. But the process, even if all you've looked at when you do your investigation is, we didn't really make an error, but we still, and we may even not have found anything we would do differently next time, but we still need to be empathic because the harm is still there. It doesn't answer those, it doesn't rise to those other levels, but the harm is still there. So you still have the exact same conversations, only you layer on some further things to those conversations, depending on the answers to those 3 levels. And I think I do want to say one thing, Naomi, is there's data to support what I'm going to say is when we physicians, most of the studies are physicians, but not totally. When clinicians make errors, we do take, it may not show, which is tremendously destructive, but there is significant ownership and grief about the error, even if it didn't reach the patient. Even near misses, people are, incredibly negatively affected. And, certainly layering on, and it was, outside the standard of care, of course, would make anybody feel worse. But I want to make sure that we get that.
I hope I didn't convey in any way that I think that there isn't an ownership. From my point of view, that's why CRPs are important for physicians and all providers as well, because it means, again, that there's communication and connection in and around who the error involves. And from my point of view, that is in terms of mental health, the best thing for providers as well. It means that instead of being in a silo and worrying about this individually and on your own, there's a way to communicate together about what happened, which I think ultimately is better for everybody.
I do, and I really want to add your point back onto mine, which is your original point, which is the danger of using the standard of care poorly and throwing it around, if you will, or just having people, physicians and other clinicians not understand it. Is the danger is what you say, which is that people will use it as a way to not hold responsibility or accountability.
And I think that happens. Right?
Yes, no, it does.
And then it sounds like even in talking about it, I'm not understanding what this must be like for the providers. I do, even if the standard of care is met, there's a patient who had a poor outcome and that weighs on them. But I really think that it's used often as a way to say, it's like a sigh of relief. The standard of care was met. Well, and the patient and family are still left harmed. And
well, that's right. So I think we're in violent agreement, which is I really do appreciate that danger of physicians and other healthcare providers using a standard of care as a way to not hold responsibility and not respond transparently and compassionately with patients and families. And that's why I think these conversations matter so much, because, Jeff Catalano knows exactly what standard of care means and where that fits in, but lots of physicians don't, right? And so I'm with you 100%.
Well, and Jeff, I have a question, Catalano, not my husband, Jeff G, which, Joe, it's so funny you called him Jeff G, because we have 2 Jeffs in our family as well, and he is Jeff G in the family. So that was just perfect. But Jeff Catalano, when you said, both sides doing an RCA, and for me, I hear again language that is against or adversarial in that. And from my point of view, in my vision, and maybe it's an ideal, and I'm just curious about whether you think it can be reached or not, but my vision would be that there would be not two RCAs, one side and the other, but an RCA that also does involve the family and patient, because they often know a whole lot and or have input that can matter. But that, in other words, one root cause analysis is done. I don't know. You said two RCAs, and it just got me thinking, oh boy, but then our language all over again is about, this adversarial.
Well, I guess the question would be, what do you think is the effectiveness or possible problems with doing the RCA involving the patient and family and presuming that that will satisfy the curiosity of both sides in working this out?
Well, certainly in many instances, the patient should be included because the patient may have experienced symptoms sooner or more seriously than the medical records may reflect. That happens all the time. The medical records are highly inaccurate many times in capturing what the patient was going through. Yet you have internal investigations like root causes or other investigations which are shielded under the cloak of a peer review protection, meaning confidential, okay, where the patient is not invited. And this can really, actually, this triggers me, I'll be honest, because what happens in the peer review process is doctors all get together in a conference room and they talk about what happened, and then they come to a determination as to whether it was avoidable or not. And then they don't share that with the patient. They don't invite the patient in many times, other than the CRP process, which is different. But they don't invite the patient in, and then the patient's perspective is not included within that root cause. But the reason I say two root causes is because I don't mean it in an adversarial way at all. I now have a case involving an elderly woman who ended up suffering a spinal hematoma that went undetected and untreated for several days while she was hospitalized for a completely different condition. This was a totally unavoidable, preventable thing. We did our own analysis because we knew a couple of facts. Number one, the hospital wasn't getting on it very quickly. It ended up going to a defense attorney who's overworked and overwhelmed. They don't have the time, the effort, the ability to put in the thoroughness that we've put in. So what do? We do it and then we share it. We share it with the other side. Here's our work product. Show us where you might see something different, okay? And oh, by the way, our client's available to speak with you because she has a lot to offer that may be very important for you to hear if you're gonna come to your own determination as to how this happened, who's responsible, was it preventable? So I'm a big believer in collaboration, but the idea of doing it jointly together has some logistical challenges that I've just mentioned that get in the way of doing a joint root cause analysis, like collaboratively together, all of you in a room or whatever, doing the same analysis. That's a little bit logistically challenging, but the result could still be the same, which is, or the goal could be that we come to something that everybody feels was the product of deep thought, examination, and yes, many times expert opinion, because I'm not a cardiologist, I'm not a hematologist. I need to bounce this off people who are super skilled in that and tell me what went wrong.
Thank you, Jeff. That's really helpful. Another follow-up question, which I think comes from some of the themes that came out in the different webinars, and also flows from this idea of a guide through the CRP process, an attorney as a guide. No matter where you say that guiding should begin, which I think there's different thoughts on that, is how do you get that guide? And so Naomi and Jeff Goldenberg, I know that you were talking how hard it is to get representation. And Jeff Catalano, you have some experience, I think, in Massachusetts, or a lot of experience with this in Massachusetts. So I would be really interested in your thoughts about how could the system be improved to allow not an attorney as an adversarial force, but really as a guide. How do you expand that network?
I'm going to turn that to Jeff because I'm curious to know too.
Okay. Well, so I guess I'll repeat what I said earlier, which is that Massachusetts, I think, has a nice model to follow, which is where we vet people ahead of time. I personally participate in this process. And there are people I just know in Boston who are doing it for the right reasons versus people who are doing it maybe not because they're so invested in this process. I don't make any judgment calls. It's just not their thing. So I personally reach out and vet these people, hear, see if they are subscribing to the same CRPC principles that we all subscribe to, And then, of course, they watch this webinar, and then they sign a document that says they have watched the webinar and they're committed to the principles. It's not super strict. It's not like it's, handcuffing them in any way. They can still be the advocate they need to be, but they appreciate that at the beginning, this is supposed to be a cooperative dialogue that is not to be an opportunity for cross-examination at the get-go. And that is one way of ensuring that people will get a good lawyer. But I will tell you one of the challenges of that, which I've learned, if the hospital is handing a list of attorneys to a patient, sometimes the patient mistakenly thinks, oh, they're like in cahoots, right? And it's not. I mean, but you can't really prevent that, because the only other choice is they, just go on the internet and Google medical malpractice attorneys. And I'm out there trying to convey the message about what this is about as much as possible. So even if you're not on the so-called list, and I invite anybody who wants to be on it to get on it, that you can still have this opportunity so long as you understand what it's about. Too many lawyers at the beginning thought this was a wolf in sheep's clothing, right? It's a way to sort of shortchange the patient. I've been spending a lot of time over the last 10 years trying to disabuse people of that notion with some success. And I think we're making progress. It's slow and steady, but it's progress.
Well, and clearly, go ahead, Joe, your hand's up.
Oh, I just want to say, but I'm back to what I was saying, which is, I think way before attorneys, Naomi, to your earlier point, there needs to be a point person who's going to guide the patient and family through the process, because it's a process. That initial thing of like, you think we know what happened. Oh, I can tell you, a lot of times we have no idea. We haven't even been able to, we need the viewpoint from the patient and family, from, this specialist, from this nurse, from this person. It takes a while to gather that data, to get like even the facts. Someone in the chat said, truth is truth. Well, it takes a bit of time, and you have to really be, rigorous about it. Like, we're really going to ask the questions. Yes, but why did that happen? And, what were the, what have you? So that's from literally the first possible moments, after that initial, this happened and we're so sorry, is making sure there is a contact person. I'll tell you what we did when I was at the Brigham, and I've seen other hospitals use this model, is it should be someone from patient-family relations or the equivalent. They're trained to pull people together, to help communication, and to make it really easy for patients and families to say, like, hey, when are we going to have that next meeting, or what's going on since then? So I think, yes, Jeff, everything you say, and you've been such a leader in this. You're, in a sense, you're sort of role modeling and training the future generation of attorneys who get it. And there's still a lot that goes on before anybody from the law is going to be involved. So I don't know, Naomi, how does that sit with you? Because I think that guide thing is huge.
I think there's a lot of value in the way you're describing it happening. And certainly it makes sense for an experienced person who deals with patients and families in appropriate ways to be part of that guide, and that would have helped tremendously for us. It also might have led us to get more support from the hospital. And I had one question for Jeff, and then I don't know if you have something else to say. Just in practical terms, what is the compensation model for those attorneys who are working in that circumstance, and how does that work out? Patients paying versus hospital paying, or people taking different fees than they might take if they were working the case as a plaintiff's attorney.
Yeah, you're still working as a plaintiff attorney, but at the same time, under Massachusetts, the principle is that you commit to a flexible fee, meaning if you can resolve a case pretty quickly, not quickly meaning, with a few discussions, internal review, analysis, but it doesn't drag out for years, and you settle up before you have to file a lawsuit and go to court, then the thinking being, in those circumstances, you'll be flexible with your fee arrangement. Now, we're not dictating what that means. There's a statute in Massachusetts that dictates how high we can charge, But the idea being that you would charge less, and I've done that many times, where the resolution is achieved before suit, before a protracted litigation. It only seems fair, and especially in smaller cases. I've taken on cases. I don't always take on the big cases. I feel like even people who have been harmed to a minor degree through absolute negligence should get some compensation. And in those circumstances, I'll reduce my fee to like an hourly rate of something very reasonable that I then end up getting from whatever settlement that we obtain. But the hospital doesn't pay for the attorney's fees. It comes out of the ultimate resolution. And that's how the attorney does get compensated, if that answers your question.
My follow-up to that is, if eventually there is a root cause analysis and the determination is that the standard of care is met, so typically in an adversarial system, there wouldn't be any financial compensation. Who pays that attorney's fees? And what I'm getting at is that there may be a whole lot of people for whom the idea that they're going to end up with an attorney's bill at the end of this process, that may be a very big barrier for them to cross, and they aren't able to then work with an attorney while they're going through the process.
Yeah, no, so every attorney who does this would be doing it on a contingent fee, meaning for free, unless and until we can get a resolution for the patient. So in the event that there is no resolution, and believe me, there are many times where I look at a case, I analyze it, I get an expert, I meet with the clients, I do all that, and ultimately have to make the hard decision that it just doesn't rise to the level of a case that deserves compensation, because not every adverse event requires compensation. I think we have to agree on that. And so when I have that discussion, it's hard, but do I end up charging them? Of course not. It's all for free. So that's a risk of the business I'm in, that sometimes I take on these cases, I look at them, sometimes even take them to trial, and I do lose. I mean, any lawyer who says any med mal attorney who says he hasn't lost a trial is lying, because it's a tough business that we're in. And the risk of it is that sometimes you go all the distance and you lose, and the client still doesn't owe the plaintiff's attorney anything. So that is the benefit to the client of the compensation system, because yes, most of my clients, I mean, here's a not so secret. Most of my clients are not wealthy. I mean, this touches on something we were going to talk about implicit bias, but many of my clients don't have the education level, or they are biased against because of they're subject to bias because of their skin color, or their race, or gender, or age, very often age, if they're elderly. And so, it's one of those things where these folks, they can't afford a lawyer. I mean, I can charge $6.50 an hour. They can't afford that. So there has to be something where, they can get good representation, and then the lawyer would get his or her fee from whatever result there is.
Thank you, Jeff. And that I do want to talk a bit about implicit bias, because I know we wanted to talk about that in this webinar, and the time is running short. I would really love to hear the thoughts of the different discussants on implicit bias and how we can really combat that in a CRP process.
Can I sort of take the lead on that?
Absolutely.
Because that is very due to part. As I mentioned, I can go on with stories about clients of mine who, because of their skin color, are suffering some traumatic event that is causing them to, become very, their behavior becomes erratic, whether they're hemorrhaging internally or whether they're becoming anoxic, and they're instead in the records determined to be combative or difficult or feisty even one time. These are Black clients of mine. And obviously in those cases, it was life-threatening. And they both ended up passing away tragically. The point being here is that I think in the CRP process, we have to recognize that just as in medicine, which they're now starting to recognize, that we need to deal with implicit bias in healthcare. The Massachusetts Board of Registration in Medicine recently decided to require all doctors to undergo 2 hours of implicit bias training. I was surprised to hear that hasn't been in place, and more surprised to hear that there's only one of 7 states that require it, because it's such a detriment to healthcare. We in the CRP process, I think, need to be face the reality that even when we're dealing with patients after an adverse event, as well-intentioned as we are, no one's going to raise their hand and say I'm racist, but the reality is we all do have our biases and our assumptions based on race that can, in many instances, negatively impact how we handle our CRP process, right? It's easy when someone doesn't speak the language. English is their second language. We obviously should make sure that there's a translator involved, or if they don't speak any English at all. That's an easy one. More complicated are the times where the individual is very young or very old, and we have to understand what's their capacity to take in the information and what do we need to do to facilitate that communication so that they appreciate what we're saying. But the point being, I think we need to constantly re-examine how we are doing our process. Are we communicating with these folks after an adverse event that is respectful of where they're coming from?
Yeah, I don't see how we cannot. I mean, I totally agree with you, Jeff, that we are all biased, and the only way to overcome that is to make our unconscious bias conscious to ourselves so that we can work against it. And one of the things that I have said around how do you deal with that when you're teaching communication skills, whether it's of consent, whether it's or post event. You could be brilliant and know everything about every culture there is, but you don't know how that patient and family are, what they believe personally, because they are a product of many different forces in their lives, their family of origin, their gender, their socioeconomic status, their race, et cetera, their sexual identity. And I think my teaching generally is don't assume anything. Ask. How is this landing for you? What are your concerns? Tell me more about how you see this. Those are questions that we have to always ask, because if we don't, then by default, it's what we think we would feel in those circumstances. And that can be way off the mark. And it also takes the burden off of us to memorize everything about every culture, which also can, even if we could, which we can't, you wouldn't be able to apply it to an individual anyway. Just because you know their country of origin doesn't mean you know what they're thinking and feeling. So I think it's yes and what you said.
Yeah, because I agree that even like when you say language is easy, well, language is easy, but that doesn't necessarily mean you understand culture, right? And then Jo, there are cultural norms and then there are individual norms. And so I think that for me, the thing I would say about bias is it's critical that we figure it out, and that one of the ways of working with the concept is the idea that in our training, how we teach how to do CRPs, that we deal with bias immediately as part and parcel how they're run, how they happen. And the idea that CRPs are principled means that there is room there for making sure that the point person, again, is somebody who is good with people, who understands how to manage bias and what that particular patient and family needs in order for the communication aspect to work well. But I think also there's obviously a dearth of information that's evidence-based about CRPs altogether, and about harm and what harm is like for patients and families. And I feel really proud and pleased that we're sponsoring through Talia's Voice a study on marginalized and vulnerable patients and the impact of harm and CRPs on them, because it means if we can understand what that experience is for them and how the role CRPs play for marginalized communities, we then can make them work for those with more privilege like us. I think, I just think we really have to begin tending to our biases and to understanding what the experience is like for everybody.
Thank you, Naomi. Such important work. I wish we had hours for this discussion, but alas, we do not. And we reached the end, the conclusion. I hope this is just the beginning, though, the beginning of conversations among all the participants in the CRPs and how we can really help them flourish. A huge thank you to our discussants today, Naomi and Jeff Goldenberg, Jeff Catalano, Jo, just thank you so much. Thank you for participating in the prior 3 webinars, and then thank you for participating today. It was such a fruitful discussion and really shows how much can you gain by breaking down these silos. At the beginning, I mentioned that this was the final in a series of 4 webinars. The prior 3 webinars can be found tape versions on the collaborative website. So if you have not watched them, please do. And then finally, just a huge thank you to everyone who joined us today. I'm going to now turn to Nicole. I know we only have about 5 minutes or so, but to moderate any questions that have come in from the chat.
Thank you, Caitlin. We have had a couple questions come in, and I'm going to start with the ones in the Q&A. And the first one was touched on this a little bit, but in an environment where trust has been lost, do patients or families trust a referral from the hospital? Jeff and Naomi, do you want to take this one?
It's a hard question to answer because when I talk about our experience, sometimes I have to tell people that it seems like the bad guys out of a John Grisham novel or something. It's sort of unbelievable, some of the things that happen. And for me, I feel like the hospital lost my trust pretty completely. I think that in general, and in a different circumstance, I can imagine being in a place where that referral would come in and I would trust it. And certainly I can imagine being in a place where I wouldn't, because I was.
And I think, just to add to that, I think if the CRP model is being followed, that's the only possibility of a hope that that kind of trust could both be reestablished and that some trust regained.
Thank you. Our next question comes from Claudia, and it relates back to the standard of care conversation. And Claudia asks, is there a different way to describe standard of care that would be more empathetic? So I don't know if any of our speakers today want to take a first pass at that question.
That is such a good question. I think a lot about that because words matter and then they influence our behavior. So here are the 3, and I'm going to need your guidance, Jeff C, for this. But the ones that I'm familiar with are standard, where we're thinking about that threshold of, okay, now it's time to think of financial restitution. Is so it's a 3rd layer of my tier of looking at of harm events. The other is negligence, and the other is unreasonable care. And I think that at least I could say generally in the medical community, that's how we think of those 3 things very similarly, the same actually. And I don't know another term, but I guess what I wanted to say is that I think we I really think we could help clinicians by explaining over and over again that even if the care is found not to meet the standard of care or it's negligence, that doesn't mean you are a bad healthcare provider. We make errors and cause harm, right, that end up being, when we review them, like we answer the question, should we really have not done that? That's kind of was what we were using at the Brigham. Like, is that just not reasonable? And they, without in any way saying that those choices that the individual clinicians made in the moment, of course they thought it was reasonable, and you could see why, right? But they were wrong, right? And people get things wrong. That's called human error, and it can result in giving care that's not, that is below the standard of care. And so I think if we could, I'm not sure we could make up a new name, but I think if we could educate so that we just explain, like, no, you can be a really wonderful human being and committed and wise healthcare provider and still be a participant in care that doesn't, meet the standard. We don't want that to happen, but it can happen. So it's not that you are a negligent person or healthcare provider. It's the care that was given by you and others was negligent. I don't know if that answers you, or your question, or Jeff, do you know, is there a phrase that you know of?
It's really hard to have this conversation. I've had it different ways with different clients. One thing I often say to a client is this the kind of thing that shouldn't have happened, or is it the kind of thing that happens even in the best of hands? And it sort of gives them a way to relate to it, that they can understand what I'm trying to tease out. And I think that's something that helps them to digest it, because if I were to give the legal definition, they would gloss over, which frankly, that's what a jury does too. And so I have to find a way to communicate it to a jury that they can relate to in their lives. And that's the art of being a trial lawyer, doing it in the right kind of way. But also at the same time, my clients are smart. They're not all well-educated, but they're smart. And they appreciate it when you talk to them in a way that respects their intelligence. And I think that if you approach all of your discussions like that, not talk down to them, not talk above them, try to find that right, whatever it is, middle road, they'll respect you for saying it. And sometimes it takes a bit of a dialogue to really figure out what that is.
And Jeff, I would just add to that I think the thing to remember is to make it easier in the discussion is that standard of care is used continuously. It's just part of the vocabulary on the provider side, but it isn't for the patient and family. It is a concept that is not just, and so in the explanation and talking about it, just remembering that can be helpful because I just think there's a divide there in terms of just language and vocabulary that needs to be managed well.
Yeah, education.
Sorry, last point on that. The language used by clinicians, not their fault, is language they use all the time with each other. Yeah. And so often they think it's so that how could people not understand what this clinical term means because they're so used to using it every single day.
Yeah.
And that often is not the case. And I think from the clinician's point of view, it's important to be mindful of the fact that even well-educated patients may not understand the specific terms that you're using that you think are so obvious because you use them every day.
Yeah, exactly.
Which is why the point person matters again, as the person who is the translator.
Translator.
It's a critical feature of the CRP model. And
I agree. That is exactly where you have to have a legal translator when you're starting in that realm, because it is very hard to explain. And, I would also argue that physicians and other healthcare providers don't really you hear negligence and it's like, are you calling me a reckless, horrible human? Which is in the way the malpractice system is set up, which you kind of have to prove if you want to, which is terrible. It's like that has nothing to do with that. But I just want to say one thing. I acknowledge, and as we all have to, that there are times, and it's rare, where there's actually reckless care. But that's not what we're talking about. That is different, where someone a healthcare provider has been reckless in care, but that's so rare. What we're mainly talking about is these, series of human errors that may or may not have reached this thing of like, oh gosh, that was not reasonable. I mean, at the moment it sounded like it was, but it wasn't in retrospect. And that's not what the standard of care is.
Okay, that brings us to the end of our time together today. I would like to thank Caitlin for moderating this series so effectively for us and give a special thanks to all of our speakers for joining us for such an insightful and engaging conversation. So thank you everyone for joining us, and we hope to see you again soon. Bye everyone.
Thank you.
Thank you.